Hello and welcome to the Stanley Law Offices Social Security Disability Benefits webinar. Today, on behalf of Stanley Law Offices, I'm Angela Moonin, and I'd like to welcome everyone who may watch this live or on replay. We are doing a series of Social Security disability benefits webinars for you to deconstruct the system, the process, so you better understand what benefits may be due to you. And joining me throughout this series is someone who the Stanley Law Offices team is incredibly proud of her work and her paralegals work. I want to welcome to the StreamYard stage, if you will, Attorney Shannon Doan. Welcome, Shannon.
Good morning.
Good morning. So today we are talking Social Security disability and the steps in that SSD process. So we're going to spend about 30 minutes today or so. Is that right, Shannon?
Correct.
Yes. And Shannon's got some wonderful slides for us. Want to encourage you, if you have questions for Shannon, and Amanda is her paralegal. Shannon and Amanda work on behalf of Stanley Law Offices across all 50 states. So if you've got a relative somewhere else in the U.S. that you feel needs to hear this kind of information, please share this with them. And again, this is being recorded today. You'll be able to watch it in Facebook Live. We're simulcasting this over onto a couple of other platforms, including LinkedIn, and it will be available on our website, on our YouTube channel, so you can share those links pretty easily. With that, I think, Shannon, let's get right into this. Yes?
Sounds great.
Okay. And you're going to see, by the way, and Shannon shared this with me. And can you talk a little bit about what's scrolling across our screen right now, Shannon?
I can. As of today, for the calendar year 2024, we have been able to recover over $2 million in Social Security back pay or back due benefits for our clients. Which is a great success, but we want to do more, and we believe that we can do more. I feel that exceeding the $2 million mark is a testament to the hard work that we do, the great work of my paralegal Amanda, and Stanley Law Offices support as well. I think it is a reflection of how hard we work and the pride we take in what we do.
And we call these the Social Security Disability Rockstar team, the Shamanda, the Shamanda team, because the two of you work so well together. And our online reviews for Stanley Law Offices are a testament to that, Shannon, the hard work that you do, the diligence and the consistency. And you'll see over and over from all of these reviews the resounding consensus of how incredibly organized, consistent, informative, empathetic, and sharp this SSD team is. So it's a credit to your leadership, Shannon, and your diligence in commitment to always doing the right thing, to making sure clients know every step of the way, which don't you find that we're going to talk the basic steps of the process. Don't you find the undercurrent of the process is that people just want to know where things are at and what to expect?
Exactly. Human nature is we want to know. We want to know as much as we can about our situation. Not knowing can create a lot of unnecessary anxiety and worry and frustration. So we take great pride in, even if it's a matter of we received just a letter from Social Security that really isn't significant in the big scheme of things, we're communicating that to our clients, because the more knowledge that we can give our clients, the more empowered they feel going through this process. It doesn't feel like they're navigating the unknown or uncharted territory. So yes, communication is always key. It's the golden rule. It's how I would want to be treated if I were the client. And that's how Amanda and I are going to treat our Social Security clients as well.
Awesome. All right. Well, I'm going to let you take this away, and then you just flag me as you need to, and I'll progress through our slides here. Okay.
Okay. We're now going to talk about what you can expect in terms of the basic steps of the Social Security process. Step number one, I have to say, is the first and the most important step in the disability process, and that is filing an application. It's the most important step because unless and until an application is filed, nothing is going to happen from a Social Security perspective. It is also important to file an application timely, because the longer you wait, you could potentially be costing yourself back pay or back due benefits. So let's talk a little bit about some of the things you should be doing in preparation for filing an application. Number one, we recommend that you gather a list of the medical conditions that you have that you feel impact your ability to work. That is important because it leads into the next step, which is assembling a list of the medical providers who treat you for these conditions that you feel prevent you from being able to work. The more information that you can put together on those two issues, so your medical conditions and the providers who actually treat you for them, ensure that we are communicating as much information to Social Security as we can about where those medical records can be found to prove those conditions. Additionally, I would recommend putting together a timeline or a list of your 5-year work history, because that is the period of time that Social Security is going to consider when evaluating your ability to return to past work. So, today, if you're filing, you would be looking back to October of 2019 generally. Another piece of information that can be important when you file your application is information about your current and former marriages. So the information that you're looking for are things like your spouse's name, the date and location of your marriage, who performed the marriage, and if you have it, your spouse's age and Social Security number. Information about your former marriages as well. This would generally be the same information that you would provide about your current marriage, as well as information about the date and location of your divorce. This would apply if the marriage lasted at least 10 years, if the marriage ended due to the death of your spouse, and you then divorced, remarried within a year, and combined period of marriage lasted 10 years or more. So essentially, to boil that down to a more usable format, if your prior marriage lasted 10 years or more, that's going to be an important piece of information to provide Social Security, because the former spouse could potentially be entitled to benefits based on your record. Other marriage information would be any marriage if you have children under the age of 16 or disabled or handicapped children from that marriage. Again, that would be information you would want to provide to Social Security because of the potential benefits that could be paid to those children. Now, what can you expect once you file the application? So let's talk about step 2 in the process. The second step in the disability process is awaiting Social Security's initial determination, its first decision. Once Social Security has determined that you're technically eligible for benefits, that means you meet the work credit requirement for SSD, or you're under the income and resource limits for SSI. We talked about the difference between those benefits in our last Social Security webinar. Once Social Security has determined that you're technically eligible for benefits, the Disability Determination Service, or DDS, will then conduct an initial medical review of your claim to determine if you are medically disabled as Social Security defines it. This initial step involves a lot of information gathering. So it's going to be information about your medical conditions, the symptoms you have on a daily basis, your functioning in terms of the limits that you have and the things that you're able to do, and a more detailed set of information about your work history. This step will also include requesting your medical records, again, so that Social Security can see what the doctors are saying about the conditions that you feel prevent you from working. At this step, Social Security may also ask you to attend what is called a consultative examination if they feel that additional information is needed to evaluate your claim. For those of you out there who have had a workers' comp case in the past, a consultative examination for Social Security purposes is somewhat similar to an IME in a comp case. Now,
an IME meaning that initial
an independent medical examination.
Yeah, independent medical exam. Okay.
Now, one of the most common questions we get from our clients is, how long should it take? How long are we going to be waiting? As of June of 2024, the average initial wait time at this initial level was 229 days. So about 7 months. Although I will say in our practice, we typically see a 5 to 6 month average as a.
I was going to see a lot of the reviews, Shannon, have spoken to that, like how expeditious, because you are so diligent on dotting I's, crossing T's, that things don't have to get kicked back. They're not right. Everything is going as smoothly as it possibly can. And you're greasing those wheels as best, metaphorically speaking, as best you can to get those decisions as quickly as possible.
Yes. We try to be very proactive right out of the gate. You know, we want to come out of the gate when the application is filed. We want to be proactive, anticipating the type of information that Social Security is going to be looking for and providing it to Social Security in real time. So one of the things that we do when we start a new case, we immediately send out, they're called medical source statement forms. Those are forms that our clients can talk to their medical providers about and ask their medical providers to provide a treating source's opinion of what their limitations are. That way, Social Security has more than just the consultative examiner's opinion. We can actually work on getting opinions from treating sources, which can be very valuable in the process. We also, again, maintain regular contact with our clients so that as new or updated medical information is coming in throughout the process, we're communicating that to Social Security in real time so that they have as much up-to-date information as we can get them at all times. That way, it ensures they have as much of the picture as we can give them when making the first determination in our cases.
First steps, right. Okay.
In terms of results, unfortunately, the statistics indicate Social Security typically denies far more claims than it approves at this first level. As of 2022, which is the last year that I've seen actual statistics for, Social Security approved about 38% of cases at the initial level, meaning they denied about 62% of cases at the initial level. We want to be very reassuring that even if it is an initial denial, it doesn't mean that it's a bad case or that it can't be successful. It means we have to file an appeal, which takes us to step 3 of the process. So step 3 is the reconsideration level. So if Social Security denies your claim initially, you then have 60 days to file an appeal, which is called a request for reconsideration. At reconsideration, the process typically involves gathering updated information, about your medical conditions, your symptoms, your functioning, your work history, and medical records. Because it has typically been a few months between the initial level and the time Social Security is making its reconsideration determination, it's reasonable to assume that there are going to be updated medical records, because seeking regular and ongoing treatment is critical to the success of a Social Security case, but also updated information from you about how you're doing in terms of your health, your symptoms, and your functioning. Because as time progresses, some conditions may get better. Some conditions may unfortunately get worse. Other conditions, someone may have just plateaued and won't be getting better or worse. So the updated information is very important in making sure that, again, we're giving them as complete a picture as possible. At this level, a new Social Security disability analyst will be assigned to your case. So it's a new set of eyes looking at all the information. And this individual may also ask you to attend a consultative exam if they feel that additional information is needed to evaluate your claim. As of June of 2024, the average reconsideration wait time was 225 days. That's nationwide. So that's pretty consistent with the wait time at the initial level as well. Unfortunately, at this level, statistics indicate, again, Social Security denies far more claims than it approves at the reconsideration level. The last statistic I saw came from 2022 and indicates at the reconsideration level, Social Security denies about 85% of claims a second time.
That's incredible to me, Shannon. And why? Because you worked on the other side of the desk as well. So you understand 360 degrees, if you will, the perspectives that are, the dynamics that are at play here. Can you, within reason, can you just quickly share why is it that, if someone's worked all their life and they are hurt, et cetera, and they think they're going about this the right way, why are so many, it just seems like a really high percentage that are in fact denied?
One of the common trends, excuse me, that I've seen, and I actually had a conversation with a client about it this morning, is particularly in someone who has had a sedentary job in the last 5 years. So that's essentially a desk type job.
Yes.
One of the common trends that we see at the first two levels is people being denied because Social Security is finding that they can go back to that past job. I can think of at least two clients right off the top of my head that at the first two levels, Social Security said, you're not disabled because you can do your past work. And we appealed all the way to the hearing level. And once we got the chance to present the case to a judge, actually talk to a person, have the benefit of vocational expert testimony, we're able to then illustrate why that prior outcome was not correct. But that's a very common reason for the denials at the first or the second level.
So this vocational, the vocational expert testimony that you speak of, Shannon, that can be a key component. Yes.
Yes, it can be an incredibly key component, particularly, like I said, when you have the individual who has that sedentary past work,
right?
It can be a very intricate and integral part of a successful Social Security case, is knowing kind of where those hidden gems of information that
right, nuances
exactly.
of information that can make, cases can be won and lost between the nuances, right? It's and because if that wasn't the case, it'd be black and white. You worked,
correct.
You did this job, you paid into the Social Security system, you can't work now. Okay, here are your benefits. It's not black and white. It's nuanced.
And I'm surprised by the number of times that people have made the statement of, I've worked all my life. It's going to be a no-brainer. There's no way they can deny me.
Right.
And unfortunately, there just aren't a lot of cases that are, for
Smooth
lack of a
sailing
better
like
phrase,
that. Right.
slam dunks.
Right.
Correct. There
Right.
are a lot of nuances. There are a lot of subtleties. And as we've talked about before, working almost 19 years on the other side of the process helps you to see how the sausage is made. You can appreciate those nuances or the subtleties that may not be obvious.
Right. And that's a great analogy. So, all right. So once you're at the hearing level, if SSA wants to deny your claim after it's reconsidered, can you walk us through this aspect?
Absolutely. The hearing level differs greatly from the first two levels because at the hearing level, we actually get the opportunity to present a case to a real live human being. So at the first two levels, Social Security is making its decision almost entirely on reviewing information on a computer screen. I certainly will not say that you can't get a lot of information based on reviewing records and information on a computer screen. But the hearing level allows us to put a personal story, put the human
It
element
fleshes it out, right? It fleshes
Correct.
everything out. Yes.
Correct. So, as with the first two levels, the hearing level is going to involve gathering updated information, particularly when it comes to making sure that the medical records are updated before the administrative law judge hearing. I can't speak for how other practitioners do it, but here at Stanley, as soon as an individual is scheduled for a hearing, I schedule a pre-hearing preparation call with each and every client. This is designed to be a dress rehearsal, if you will, for the hearing, to get them as prepared as we possibly can for the hearing. Again,
Yes.
kind of going back with what we talked about earlier, it's human nature to be nervous about something that you don't feel that you know what to expect.
Yes.
So we want to take the mystery out of that. We want to make sure our clients wake up on the morning of their hearing and feel that they are ready for it. So during that pre-hearing preparation call, we're going to talk about the hearing format. I'll be able to share any information I have about the particular judge, so that our clients have an idea of what to expect. In terms of the judge's personality, they're all different, and it, again, is helpful to know what to expect from your judge.
Absolutely.
We'll also walk through the issues that the judge is going to be deciding, so that each client has a good understanding of how the decision is going to be made. We'll go over any questions that I have based on my review of all of the evidence in Social Security's file, again, so that we can ensure that the record is complete going into the hearing. And most importantly, I feel we're going to walk through the questions that you can expect to be asked at the hearing, whether it is from the judge or from me. That way, our clients have a really good idea of exactly what to expect in terms of questions. And I get the opportunity to hear them answer the questions, which allows me to take notes that I can use during the hearing, to ensure that we are covering that important information that can be helpful in getting a favorable decision. We don't want people to end their hearing and say, I had no idea what to expect, and that is nothing that I was prepared for. That is not how we want our clients to feel.
Sure.
As of June of 2024, the average hearing level wait time was 361 days at the hearing level. That can vary, I will say, depending on who the judge is. Some judges have more hearings or move cases more quickly. So that average wait time is exactly that. It may not be that long in your case, or it may be even longer in some cases. A positive thing about the hearing level is the chances of success at the hearing level are typically higher than the initial and the reconsideration, or the first and second levels.
Okay, so once you get at that level, now you're getting somewhere. If you can, after you've gotten, in other words,
Correct.
if you've gotten once you've gotten through those first couple of hurdles, now you have the probabilities start to fall in your favor.
Correct. Again, going back to those 2022 statistics, about 1 in 2 people were successful at the hearing level. And that is almost as much as the first and second levels combined.
Combined, sure.
So the chances of success do go up at the hearing level.
So the longer you are in the funnel, so to speak.
Correct.
Yes.
Correct.
Okay. That's a good thing. I know people don't want something to go on for a year, but if it means that the outcome has a much higher probability of being in their favor, then that's a good sign.
Correct. And I've said this to many clients, and I think some of them have even mentioned it in the reviews. We don't give up. We don't just accept the denial and give up. Persistence pays off. Social Security is definitely a team sport, where we're teammates and we work together, and you just don't give up. You keep persisting, and that's how the process can pay off. However, not everyone will be successful at the hearing level. So what comes next in the process? This is where step 4 comes into the process. Step 4 is the appeals council level. And that is an appellate branch with Social Security. And we can ask them to review an administrative law judge's decision. Currently, the appeals council is reporting an average processing time of 15 to 18 months. Again, that is average. Some cases, decisions come sooner. Other cases, we've seen it has taken a little bit longer. But 15 to 18 months is a reliable estimate. At the appeals council level, they're not going to look at a case and make their own brand new decision. The appeals council level involves reviewing the judge's hearing decision to determine if a certain set of errors was present. So they're going to look at things like if the administrative law judge abused his or her discretion, if they find that the hearing decision contains an error of law, or if they feel the hearing decision was not supported by substantial evidence. If the appeals council finds if any one of those errors is present, they can send the case back to the judge to do another hearing, or in limited circumstances, they can also issue a favorable decision on their own. Again, in terms of success at this level of the process, statistics show the appeals council typically denies more appeals than it approves. And I believe that the 2022 statistics were somewhere in the 80 to 85% range in terms of appeals being denied. However, again, persistence pays off. So if the appeals council denies your appeal, the next step in the process is going to federal court. You have 60 days from the appeals council decision to request the review. And statistics show a significantly higher chance of success in terms of appeals at the federal court level. I believe, if I remember correctly, that 2022 statistic showed that about half of federal court appeals are successful. So again, moral of the story is a denial does not automatically mean that a case cannot be successful. It means that you need to file an appeal and to keep pursuing the process. Because again, there are a lot of subtleties and nuances in the process that the longer you appeal, the better the chances are that someone is going to appreciate the significance of that nuance in terms of the decision. Last but not least, overall, going back to that 2022 set of statistics, about 1 in 3 processed disability applications were approved. So about a 33% overall success rate for processed applications.
Well, that's a national statistic,
Correct.
Shannon, and I'm not to put you kind of on the spot, but putting you on the spot. what on average, it seems, now it's just my impression, $2 million recovered to date already. And based on the number of reviews alone every week, I know you handle a large caseload and you're in all 50 states. But 1 in 3, your odds are better than that. Not that there are any guarantees here, but my impression anyway is that the Stanley Law Offices SSD team people's odds are better than 33%.
We certainly like to think so. And again, that's why we try to be proactive right out of the gate. We want to get ahead of the game, work on developing the opinion evidence, make sure that we're communicating regularly with our clients about any new or updated information. Because the more information we can get to Social Security earlier in this process, the better our chances of success are at that first or second level, which is always the goal.
Yes.
I enjoy doing hearings. I feel very prepared when it comes to hearing days. But ultimately, the goal is to not go to the hearing level.
They have to get to that level. Yeah,
Correct.
I get that.
Certainly if we have to go to the hearing level, we will go without hesitation and be fully prepared when that hearing date comes. But ultimately, our goal is always, again, getting a successful result at the first or second levels.
So we can, is there any, I want to share with people, you can reach out to Shannon through the info@stanleylawoffices.com. You can read more about Shannon on stanleylawoffices.com. If you look at Meet Our Team, there's a complete rundown of Shannon's background, her interests, her devotion to what she does in her career, and just a stable of professional experiences over the last how many years at this point, Shannon, collectively?
I had almost 19 years on the Social Security side of the process, working in different attorney capacities, and almost 2.5 years on this side of the process. So about
with an amazing track record in these last 2.5 years.
Correct. We're building momentum and we want to keep building.
Yeah, that's wonderful. So you can reach Shannon, as I said, through info@stanleylawoffices.com. You can also call the Stanley Law Offices 1-800 number, which is 1-800-608-3333. Now, we do have 6 offices throughout upstate New York and Pennsylvania. But again, if you are anywhere, these are all of your cases are not handled in person, Shannon. They're handled virtually. Am I correct? In the entire SSD process?
That is correct. And the Social Security process is one that does lend itself to a virtual process. Everything can be done virtually, whether it is by communicating with clients, by phone call, by email, by video conferencing. The process lends itself to virtual. It doesn't detract, I would think, as our track record shows, it doesn't detract from the success rate. It also makes it more convenient. Sometimes people with certain medical issues, driving, finding parking, getting in and out of an office, doesn't always lend itself to being very easy for people to do. This way you can do everything from the comfort of your home.
And because, people's time is so precious as a resource, that's something that's often overlooked. And I know both for workers' compensation as well as Social Security disability, your systems actually were kind of out ahead of and we're doing virtual hearings, et cetera, even before virtual became a thing, during the pandemic, et cetera. Much of the law processes in your arenas were already out ahead of the rest of the legal industry in doing those virtual consultations and hearings, et cetera.
Yes.
So it's an arena that you're very well adept at. And again, I would encourage you, regardless of what state you live in the United States, Shannon, Amanda, the entire team at Stanley Law Offices is there for you and can get the process underway. And as you can see, Shannon, you may want to reaffirm this, not wise to go it alone.
It is not. Again, as we've outlined, there are lots of different steps. When it comes to Social Security appeals, there are very strict deadlines. And when you're trying to keep up with multiple medical appointments, health issues, keeping up with those deadlines is just adding a lot to your plate. You know, gathering your own records, putting information in a format to be electronically submitted to Social Security. Those are just some of the things, but more importantly, having an experienced team behind you that is available to answer the questions about why is this happening or what does this mean? You know, if you're not familiar with the process, it can feel overwhelming because there are a lot of terms, a lot of issues that just aren't familiar to the average person.
The language alone, right,
Correct. Having that experienced team to answer your questions can be invaluable.
All right. So with that, Shannon, how are you compensated? How is the firm compensated in a Social Security disability case? Let's clarify that before we close out and say goodbye.
The Social Security fee structure is a contingent fee basis. And what that means is there will only be a fee if, number one, we're successful, meaning you get a finding of disability. And number two, the claim results in back due benefits. Even if we're successful, if there are no back due benefits, you know, for example, the case is approved quickly. We've had several clients in the last year or so whose claims have been approved so quickly there were no back due benefits. Those clients don't owe us a fee. Social Security does have a set fee structure. So how the fee works is it is capped at, and the wording is a little wonky. I'll go ahead and put that out there. The lesser of 25% of the back due benefits or the statutory maximum, which is currently $7,200. What that means in numbers, if someone has $10,000 in back due benefits, the most the fee is going to be is $2,500 because that is the smaller of those two amounts. If someone has $80,000 in back due benefits, the most the fee is going to be is that statutory maximum, which is currently $7,200. Because again, that is the smaller amount. 25% of $80,000 would be $20,000. And that is far more than the statutory maximum.
Than the cap, right?
Correct.
Okay. All right. And so the next in our series, Shannon, can you speak quickly to that subject and why someone would want to join that particular webinar or share it with a loved one?
Absolutely. We've talked in the first webinar, the first in the series, about the difference between SSD and SSI benefits. Today, we've talked about what to expect in terms of the process. The next webinar that we're going to do, we're going to talk about how Social Security makes its decisions, those factors that it considers, so that you can understand the pieces of the puzzle and how they fit together, and potentially how your case may fit into the factors that Social Security is considering.
All right. Wonderful. Yes. So just stay tuned to our social media feeds. That will be promoted in advance. You can join live on any of the social media platforms that we mentioned earlier, Facebook, LinkedIn, YouTube. You can go to our website, learn more about Shannon and her team, and take a look at our Google reviews online and see how amazing this Social Security disability team performs consistently month after month on behalf of clients. And it's a testament again to both wisdom, experience, direct experience, as well as the personalities and individuals of both you and Amanda, how well you work together and how devoted you are to doing the right thing and making sure that people get their benefits that they are due and that they have paid for and worked hard for all their lives. Anything else you want to add, Shannon, before we say goodbye?
Not that I can think of, other than if you're curious, if you think maybe it is time to pursue disability and you're not sure how your case fits into how Social Security reviews files, reach out and give us a call. We'll talk to you about what we see as the strengths or the weaknesses. And if it's a case that we feel is a solid case to go ahead and start pursuing.
All right. Excellent. You take care in your corner of the world, Shannon. Thank you so much for today. And when we are ready to put the next one forth in this series of Social Security disability webinars, again, you'll see all those details and you can join us then. Thank you. And on behalf of Joe Stanley and Stanley Law Offices, you can visit us at stanleylawoffices.com. Stay safe. Stay healthy. Enjoy your fall season.
Have a great day, everybody.